Welcome to Chapter 4, Civil Liberties and Civil Rights. Although they are often discussed together, civil rights and civil liberties are not the same thing. Civil liberties are defined as individual rights and personal freedoms with which governments may not interfere. That is, they are protections for Americans from the government. Civil rights are protections of citizen equality provided by the government. Although the United States was founded on the ideals of liberty, equality, and democracy, its history of civil rights reveals a gap between these principles and actual practice. Civil liberties, such as the freedom of speech, are protected from improper government interference. Even speech that is offensive to most people, such as the views of the Ku Klux Klan, cannot be restricted by government. However, when the rights and liberties of one group threaten the rights and liberties of another, a question arises over what action the government should take. Americans have always put a lot of stock in their freedoms. We think we live in the least restrictive country in the world, so we celebrate our freedoms and are proud of the Constitution, our laws, and traditions. But in order for us to live together peacefully, there are limits to our freedom. The freedom to do some things doesn't mean the freedom to do everything. We are very protective of our rights and liberties. They equal our freedoms and privileges as Americans. When rights and liberties are prefaced with the word civil, they take on a more specific meaning and don't mean exactly the same thing. The rights and liberties of citizens can be controversial because they sometimes resemble a zero-sum game. In the cross-burning example, one person's right to not be intimidated by a cross-burning is in direct conflict with someone else's right to express themselves through cross-burning. Courts and other branches have resolved these issues in a piecemeal fashion. Most of these controversies discussed are not clear-cut based on ambiguities in the Constitution. Shifting views, both in society as well as on the Supreme Court and in other branches of government, have led to shifting definitions in terms of the rights of citizens. Often we hear people speak about what is fair and what is my right. Such notions are rooted in the substance and procedures of civil liberties guaranteed in the Constitution. People often think of civil rights as special laws for minority groups, which is inaccurate. A person with any demographic profile can have a civil rights claim or turn to the U.S. Commission on Civil Rights or another venue for information and services regarding his or her specific situation. These two concepts can be quite confusing. Civil rights involve the government stepping in to prevent rights violations by individuals, groups, or other governing bodies. Government must treat all citizens equally, apply laws fairly, and not discriminate against certain groups of people. Civil liberties are protection from government intrusion upon the liberties of individuals. They protect you from government action, and they keep government limited. Civil rights have been expanded considerably since the nation's founding. Slavery was abolished, and voting rights were extended to former slaves. Women were guaranteed the right to vote with the 19th Amendment, and also were citizens 18 years and older. Rights and liberties can often be in conflict, as the cross-burning example pointed out. Rights ensure that claims upon government are fulfilled and that people are treated fairly and equally. These are things like freedoms of assembly, religion, and privacy, and are among the civil liberties contained in the Bill of Rights, which we'll talk about later, and also contained elsewhere in the Constitution. Thomas Jefferson said that a Bill of Rights is what people are entitled to against every government on earth. While liberties ensure freedom from improper government interference, think of liberties as limits on government action. The Anti-Federalists, as you recall from the last chapter, saw the potential for government abuse of power without a Bill of Rights. The Federalists agreed to an unwritten but unequivocal pledge to add a Bill of Rights. The resulting Bill of Rights is seen as defining the private sphere of personal liberty. Remember from the last chapter that the Bill of Rights was added to the Constitution after the urging of the Anti-Federalists, who wanted to make sure that the people would be protected from interference from the government into personal liberties. It could have been called the Bill of Liberties, because the provisions that were incorporated in it were seen as defining a private sphere of personal liberty. The Bill of Rights did not initially apply to the states, it only applied to the federal government. States were not bound to provide or protect the rights found in those amendments. In 1897, the Supreme Court began the process of incorporation with the idea of eminent domain, when the government can take property for public use as long as there is compensation. This was the first time that the Bill of Rights was actually started to apply more broadly than just to the federal government, and that's called incorporation. And interestingly, the right to bear arms was not formally incorporated until 2010 in the case of McDonald versus Chicago. Chicago had a city ordinance making it difficult to own a gun within the city limits, and the Supreme Court overturned this law. thus incorporating the Second Amendment. There are two dimensions on civil liberties: substantive, which are the limits on what government can and cannot do, like they cannot establish an official state or national religion, and like I said, they cannot seize property without compensation. And procedural, as I mentioned, these are rules regarding how the government must act. They must guarantee that citizens receive the due process of law. So in further steps to incorporate the Bill of Rights to the states, in 1925, the Supreme Court ruled that freedom of speech applied to the states, and it was declared a fundamental personal right protected by the Due Process Clause. In 1937 and 39, additional Supreme Court rulings protected additional freedoms from impairment by the states. It ruled that freedom of the press and freedom of assembly and petitioning of the government also applied to the states. On page 102 of the text, you can see a chart that outlines how the Bill of Rights were incorporated into the 14th Amendment. The best way to examine the Bill of Rights today is to take each of the major provisions one at a time. The Bill of Rights begins by guaranteeing freedom of religion, and the First Amendment provides for that freedom in two distinct clauses, the Establishment Clause and the Free Exercise Clause. The Establishment Clause has had different interpretations over the years. One view is that it prevents the establishment of an official church, and this interpretation reflects the views of many of the First Amendment's authors. So basically it says the government cannot favor one religion over another, and it's not prohibited from providing funds to religious institutions, but the funding or other assistance cannot show favoritism. And the third view is that some people argue that there must be a wall of separation between church and state. And they say the government cannot breach the wall between church and state, but there's disagreement, however, over the height of the wall. Prayer in school is one such area of contestation, and although the Supreme Court has consistently disapproved of government financial support for religious schools, even when the purpose has been purely educational and secular, it has permitted certain direct aid to students, such as in the form of busing. Now, the Free Exercise Clause of religion establishes the right to personal belief in any religion and the right to practice that religion. It also protects the right to be a non-believer. West Virginia State Board of Education versus Barnett in 1943 is the precedent-setting case involving free exercise. The court upheld the rights of children of Jehovah's Witnesses to refuse to salute and pledge allegiance to the flag on the grounds that their religious faith does not permit it. In recent years, the principle of free exercise has been bolstered by statutes prohibiting religious discrimination by public and private entities in a variety of areas, including hiring, land use, and the treatment of prisoners. The book states that freedom of speech and of the press have a special place in American political thought, primarily because democracy depends upon the ability of individuals to talk to each other and to share information. A democratic nation could not function without free and open debate. This debate is seen as an essential mechanism for determining the quality or validity of competing ideas. In 1938, the Supreme Court held that any legislation that attempts to restrict these fundamental freedoms and the free exchange of ideas must be subjected to additional judicial scrutiny, and this became known as strict scrutiny. The doctrine of strict scrutiny places a heavy burden of proof on the government if it seeks to regulate or restrict speech. Americans are assumed to have the right to speak and to broadcast their ideas unless some compelling reason can be identified to stop them. It's important to note that strict scrutiny does not mean that speech can never be regulated, because some forms of speech are entitled to a greater degree of protection than others. Political speech was the activity of greatest concern to the framers of the Constitution, even though some found it the most difficult provision to tolerate. Political speech is highly protected by strict scrutiny and legal standards. This protection extends to actions expressing political ideas, even such as giving money to a political cause or going to a protest. And this speech is protected unless it will lead to immediate harm. Example, like you can't yell fire in a movie theater. So Schenck versus the United States in 1919 introduced the clear and present danger test. That was when the test for when government intervention or censorship can be permitted. The court ruled that speech encouraging such as draft resistance constituted a clear and present danger and thereby was not protected speech. Freedom of speech implies and includes freedom of the press. With the exception of the broadcast media, which are subject to federal regulation, the press is protected under the doctrine against prior restraint. Prior restraint is any efforts by government to block publication of material it deems libelous or harmful. This is also known as censorship. Except in the most extraordinary of circumstances, the First Amendment prohibits government agencies from seeking to prevent newspapers or magazines from publishing whatever they wish. Another press freedom issue is whether or not journalists can be forced to reveal their sources of information. Journalists contend that if they do not promise to keep the confidentiality of their sources, the flow of information will be reduced and press freedom jeopardized. Almost every state has a shield law to protect their sources, but there is no shield law at the federal level. There are 4 categories that fall outside the guarantees of the First Amendment when it comes to the print media. The first one is libel and slander. The press can be sued for statements made in reckless disregard of the truth. When written, such speech is called libel, and when spoken, it's called slander. The emergence of the Internet has led courts to decide whether libel laws apply to Internet content. Federal courts have generally absolved Internet service providers from lawsuits over content posted by others. Note that if the press harms a private individual by publishing a falsehood, the standard for that individual to sue for damages is lower. It's easier to sue under those conditions. Public individuals have much more difficulty because the nature of their status makes them subject to media scrutiny. Broadcast media are especially sensitive to this rule, and they are only a small part of the media today, because the federal government licenses their airwaves and the ability to convey information. They can be restricted in ways that print media cannot. Obscenity and pornography. It wasn't until 1957 that the Supreme Court confronted the issues of obscenity and pornography and stated that work should be judged obscene only when it is utterly without redeeming social importance. And then in 1964, Justice Stewart stated that he found pornography impossible to define, but I know it when I see it. The third category is fighting words. Speech is protected until it moves from the symbolic realm to the direct incitement of damaging content. The fighting words doctrine was established with the Dennis v. United States in 1951, and there the Supreme Court ruled that there is no substantial public interest in permitting lewd, obscene, profane, libelous, or fighting words. However, the court has reversed almost every conviction based on arguments that the speaker used fighting words. And the fourth and final category is commercial speech. Commercial speech, such as newspaper or television advertisements, has only partial First Amendment protection because it cannot be considered political speech. It is subject to regulation, although it is also recognized and protected for the part it plays in the free flow and sharing of information. The book states that the Second Amendment was included in the Bill of Rights to provide for well-regulated militias to enforce the security of a free state. This was to be the backing of the government for the maintenance of local public order and national defense. At the time, militia was understood to be a law enforcement resource for state and national governments. Militias were separate from professional armies, which were under the purview of Congress. While the right of the people to keep and bear arms was linked to citizen service in militias, many have argued that the Second Amendment also establishes an individual right to bear arms. In 1939, the Supreme Court upheld a federal gun law where they concluded that the Second Amendment pertained to the preservation or efficiency of a well-regulated militia. And following that decision, the Supreme Court was silent on the subject for almost 70 years. And during that time, states and local governments across the country established their own rules which differ greatly. For example, in California, the possession of an assault weapon is banned, and you need a permit to carry a concealed weapon. You need a permit to carry a concealed weapon here in Pennsylvania, too. However, in Wyoming, there is no ban on any type of gun, and permits aren't required. In 2008, the court ruled that the Second Amendment provides a constitutional right to keep a loaded handgun in your home for the purposes of self-defense. And like I said at the beginning, the McDonald versus Chicago in 2010, that generated a ruling that effectively applied the Second Amendment to the states and localities, meaning that the states and local governments cannot ban the ownership of a firearm in a person's home. A series of tragic shootings in recent years, including the killing of 20 elementary school students in Newtown, Connecticut, 50 people at a gay nightclub in Orlando, 59 people at a concert in Las Vegas, and 17 people at a high school in Parkland, Florida, has kept the issue of gun laws firmly on the national agenda. This graphic shows the different states and how they have background checks on their firearm sales. Now, although state gun laws must conform to the Second Amendment as interpreted by the U.S. Supreme Court, laws concerning gun sales and ownership vary widely from state to state. It is much more difficult to buy a gun in, say, New York or California than in Texas or Kentucky. This map shows states that require criminal background checks for the sale of all firearms, only handguns, or none when purchasing firearms. While federal law requires background checks when purchasing a firearm from a licensed seller, only 21 states require them from an unlicensed sellers as well. Except for the First Amendment, much of the battle to apply the Bill of Rights to the states was fought over the various protections to individuals who are accused of a crime, who are suspects in a crime, or who are brought before the court as a witness to a crime. And the words due process actually do appear in the Fifth Amendment. Together, these amendments, the 4th, 5th, 6th, and 8th, are the essence of due process of law. The Fourth Amendment guarantees the security of citizens against unreasonable, or also known as improper, searches and seizures. In 1990, the Supreme Court described the Fourth Amendment as such. A search comprises the individual interest in privacy. A seizure deprives the individual of dominion over his or her person or property. But and that led to the exclusionary rule. This is the ability of courts to exclude illegally obtained evidence, and it was confirmed in Mapp v. Ohio in 1961. This means that all evidence obtained by searches and seizures in violation of the Constitution is admissible, even if the person is clearly guilty. That person cannot be convicted with illegally obtained evidence. The Fifth Amendment covers court-related rights, the right to a grand jury, and the grand jury determines whether sufficient evidence is available to justify the trial, and also protects against double jeopardy, and this protects the person from being tried twice for the same crime. It also protects people who are under arrest, making sure that they are informed of their rights, and those are called the Miranda rights. So basically, it's when the police say to the criminal, you have the right to remain silent. It also protects against the right against self-incrimination. I'm sure you've heard people say, I plead the Fifth, when they don't want to incriminate themselves. And the last fundamental clause of the Fifth Amendment has to do with the eminent domain. Government can take private property for public use, but it must show a public purpose. And the government also must make fair payment for that property. The Sixth Amendment is crucial for a fair trial. It guarantees the right to a speedy trial and the right to confront witnesses before an impartial jury, and it also guarantees the right to counsel. Gideon v. Wainwright in 1963 stated that anyone facing imprisonment has the right to an attorney, even if they're unable to afford one, and that's where they would get a public defender. And the Eighth Amendment bars cruel and unusual punishment. This amendment prohibits excessive bail, excessive fines, and cruel and unusual punishment. The death penalty is allowed, but it requires due process, and the states decide whether to allow the death penalty. If execution is allowed, the states determine the method. South Dakota permits capital punishment, the death penalty, and only allows it to be done by lethal injection. Wyoming allows lethal injection and lethal gas. Utah allows lethal injection and firing squad, and Florida and South Carolina permit lethal injection and electrocution. Although the word privacy never appears in the Bill of Rights, there is general agreement that a right to privacy emanates from the first 10 amendments. The idea behind privacy is simple. People have a right to be left alone from government or other persons' interference in certain personal areas. The Ninth Amendment says that rights exist that are not explicitly delineated in the Constitution. One of the most important cases related to the right to privacy was Roe v. Wade, which established a woman's right to seek an abortion. However, the decision has remained highly controversial, with opponents arguing that the Constitution does not guarantee this right. While the Supreme Court has continued to affirm a woman's right to seek an abortion, it has limited the right, approving restrictions as long as they do not pose an undue burden. Like any important principle, once privacy was established as an aspect of civil liberties protected by the Bill of Rights through the 14th Amendment, it took on a life of its own. In a number of important decisions, the Supreme Court and lower federal courts sought to protect rights that could not be found in the text of the Constitution, but could be discovered through a study of philosophic sources of fundamental rights. The 14th Amendment is the one that guarantees civil rights to citizens. It guarantees equal protection under the law through the Equal Protection Clause. No state shall make or enforce any law which shall deny to any person within its jurisdiction the equal protection of the law. Together with the 13th Amendment, which abolished slavery, and the 15th Amendment, which guaranteed voting rights for African American men, these are known as the Civil War Amendments. They seem to provide a guarantee of civil rights for the newly freed black slaves. The very simplicity of the Equal Protection Clause of the 14th Amendment launched a century of political movements and legal efforts to press for racial equality. These efforts for racial equality inspired many other groups, including women, the disabled, and LGBTQ individuals, to seek new laws and constitutional guarantees of their own civil rights. Congress passed the Civil Rights Act of 1875, which was intended to protect African Americans from discrimination in public accommodations. It was later declared unconstitutional by the Supreme Court. In Plessy v. Ferguson in 1896, a separate but equal rule was established that said that public accommodations could be segregated by race as long as facilities were equal. The NAACP, originally known as the National Association for the Advancement of Colored People, led the legal fight to change the separate but equal doctrine. The NAACP was established in 1909 and sought to win equal political rights for people of color. It used tactics such as political pressure and litigation. Court cases prior to 1954 gave them hope that the separate but equal doctrine might change. Some rulings in the 40s and 50s began to chip away at its foundation. But then came Brown v. Board of Education in 1954. The premise of Brown v. Board of Education was that an African-American father wanted his daughter to go to the closest school to their home, which happened to be a white school. The little girl had to walk through a dangerous railroad yard to get to her bus stop to be bused to the black school. In Brown v. Board of Education, the court overturned the separate but equal doctrine. This ruling had very significant consequences. States no longer had the power to use race as a criterion of discrimination in law. The national government now had the power to intervene against discrimination by state governments. After Brown v. Board of Education, the court relied on the strict scrutiny test, which placed a burden of proof on the government to show the law in question in racial discrimination cases was constitutional. Most states initially refused to cooperate with the new laws. So even when de jure segregation, which was by law segregation, ended, de facto segregation, which is by fact, remained. There were many types of social protests after Brown. Discrimination remained in voting, employment, public accommodations, and social and economic activity. And more demonstrations mounted. For instance, the Montgomery bus boycott started after Rosa Parks refused to give up her seat. And then there was the March on Washington, where Reverend Martin Luther King Jr. gave his famous I Have a Dream speech. I also recommend, if you're interested in this era of our history, to read or watch some videos on the freedom fighters, because they are very, very powerful images of what was going on in our country during that time. The book explains how Congress used its legislative powers to help make equal protection of the laws a reality by passing the Civil Rights Act of 1964. The Civil Rights Act of 1964 prohibited major forms of discrimination against racial, ethnic, national, and religious minorities, and women in voting registration, schools, public accommodations, and the workplace. By declaring discrimination by public employers and state governments, including school districts, illegal, the Civil Rights Act provided for administrative agencies to help the courts implement the new laws. The federal government was empowered to desegregate schools and was also able to withhold funds from any school district who refused to cooperate and continued to practice racial segregation. Although 1964 was the most important year for civil rights legislation, it was not the only important year. The Voting Rights Act was passed in 1965, which significantly strengthened legislation protecting voting rights by barring literacy and other tests as a condition for voting in the 6 southern states that refused to cooperate. It made it a crime to interfere with voting and providing for the replacement of local election registrars with federally appointed registrars in counties that were significantly resistant to allowing eligible African Americans to register to vote. The 1965 law finally led to a dramatic increase by voting in African Americans, meaning that it took almost 100 years to carry out the 15th Amendment. Voting rights were also strengthened with the ratification of the 24th Amendment in 1964. This abolished the poll tax, which was another way to disenfranchise African American voters and also other less affluent voters. Affirmative action programs try to redress past wrongs by promoting employment and educational opportunities for women and African Americans and other disadvantaged groups. These programs can take many forms, from actively seeking out women and minority applicants for positions, to creating positions that are designed to be filled by a woman or minority, or to creating racial or gender quotas for businesses and organizations. An affirmative action program can use two novel approaches. And one is where race or some other status is counted as a positive rather than a historically negative factor. And there's also compensatory action to favor members of a disadvantaged group who themselves personally may never have been the victims of discrimination. Court rulings have strictly limited the use of quotas and other explicit forms of affirmative action on the basis that some groups feel that they amount to reverse discrimination and limit the number of, let's say, white male high school students who might be accepted to a certain college because affirmative action allows for more women and minority races to be accepted, even though those white male students are just as qualified or even more qualified. In the Bollinger cases, the Supreme Court did say that diversity is a criteria that can be used in evaluating a candidate for admission, but it cannot be the sole or determining criteria. So there were a couple cases that regarding affirmative action that were based upon like who should bear the burden of proof. And one was Regents of the University of California versus Bach. In this case, affirmative action was upheld and quotas and separate admission for minorities was rejected. And the burden of proof was put on the defendant. And then the other one was called Grutter versus Bollinger in 2003, and this applied a strict scrutiny test to a law school's policy. And it found that the law school's admissions process was narrowly tailored to the school's compelling state interest in diversity. So affirmative action is very controversial, and even though it tries to correct past wrongs, it doesn't always do that because then it may discriminate against other people, other types of people by accident. Americans have also fought gender discrimination. Women have organized themselves to fight against gender discrimination. In 1986, the Supreme Court recognized two forms of sexual harassment: quid pro quo harassment, which was an explicit or strongly implied threat that submission is a condition for employment, like by threatening someone to work overtime or threatening someone to embezzle money. You have to submit to these criteria in order to keep your job. There's also another form of sexual harassment called the hostile work environment, where you have offensive or intimidating employment conditions, where perhaps there are some women and this works both ways. You can have where sexual harassment of women against men and men against women. And sexual harassment is a relevant topic even today. Women have also fought for civil rights in employment. One of the things they have fought for is pay discrimination, but the Equal Pay Act of 1963 made pay discrimination illegal, and the Lilly Ledbetter Fair Pay Act of 2009 gave female workers expanded rights to sue in cases where they were making less money. Women's pay is still not equal to men's pay, but the gap has been reduced in recent years. Using the most recent Census Bureau data from 2008, women of all races earned, on an average, just 82 cents for every $1 earned by men of all races. Another way that women organized to fight gender discrimination was through the Equal Rights Amendment to the Constitution. It easily passed Congress since 1972, but fell three states short of final ratification. The book describes how Native Americans occupy a unique place in the American equality landscape. Early Supreme Court decisions did not recognize Native Americans as American citizens, but they were unfortunately still placed under the control of the national government. Native Americans were forcibly removed from lands, attacked in military campaigns, and subject to extensive discrimination throughout our history. But in 1924, Native Americans were collectively naturalized. In 1975, they were granted federal voting rights protections in the amendments to the Voting Rights Act. The Lau decision in 1974 established the right of Native Americans to be taught in their own languages. In 1987, the Supreme Court freed Native Americans from state regulations prohibiting gambling. The establishment of casino gambling on Native American lands has brought a substantial flow of new income into some reservations. It's important to know your First Amendment rights. because they are often the ones that affect they are the ones who affect your everyday life. So rights and liberties controversies continue to exist due to the vagueness of the Constitution and to the evolution of society. The debate over gun control in the United States continues to play a role in these controversies. For now, the court has defined the group that needs protection as the gun owners, the people wanting to use guns to protect themselves, and not the people who might be harmed. The same issue can be addressed with abortion. Shifting views in Congress, the presidency, and by members of the Supreme Court also produce changes in our understanding of rights and liberties. There is no clear answer as to where the line should be drawn in civil rights and civil liberties. As our nation becomes more diverse, equal protection of the laws becomes more and more important. We need to consider things like preserving an individual's privacy over the safety of everyone. These are big issues, especially in light of domestic terror attacks and the government's effort to stop them. The protection of civil rights and civil liberties will continue to be an interesting topic, and one thing we should definitely be aware of is the Supreme Court decides new cases each year in response to the civil rights revolution, which began with African Americans and has broadened to include women and Latinos, and also to address matters as sexual orientation, sexual identification, and immigration status. As the nation becomes more diverse, equal protection of the laws will become more and more important. There are 3 websites here where you can check out more about your First Amendment rights, and if you would like to know more about gun laws or abortion laws in different states, you can go to the National Council on State Legislatures. It's ncsl.org, I believe, and you can look there for information on different issues in different states, like marijuana, abortion, gun laws, capital punishment, things like that. They do a good job of sorting it all out. If you have any other questions regarding Chapter 4, let me know. This is the last chapter in the first section of the class. So the first 4 chapters, we will have an exam over all of those. So let me know if you have any questions, and have a great week.